The prayer for bail stands rejected at this stage. Item 1.
Lordship, may I please, Your Lordship. Lordship, I beg to mention one IA, Your Lordship, for correction, Your Lordship. May I please?
Which one? From which list?
I'm praying for listing one IA criminal, Your Lordship. Your Lordship has granted bail in one criminal appeal, Your Lordship, but due to non-mentioning of case number, Your Lordship, the trial court is not accepting the bail bond, Your Lordship.
Today?
Not as per Your Lordship convenience, Your Lordship.
Now, is it to be placed before me?
Yes, Your Lordship. Your Lordship has granted bail, Your Lordship.
Pardon?
Your Lordship has granted bail, Your Lordship.
Yes. Okay. When can we have it? It is from principal seat. This is from principal seat. So if I allow, when will it be listed? How will I have the file? Tomorrow. All right, tomorrow.
Much obliged.
Item 1.
Please, Lordship. Lordship, this is second bail application, Lordship. And Lordship, today is custody period is 76 days, Lordship.
This is Mukesh Ali.
Lordship.
Mukesh Ali.
Yes, Lordship. Item 1. Sorry. I have been languishing in jail for 76 days till today, and this is a second bail application. Statutory period is 90 days, Lordship. Lordship, CD. If you call the CD, the statutory period will be over, I think, Lordship.
Okay, we call for the CD and fix it on Wednesday. Lordship.
Lordship.
All right. I'll not counsel for the petitioner. This is an application under students suit. Call for the CD. List again on. Give witness this date. Okay. Item 2.
Obliged.
May it please Your Lordship.
Yes.
Yes. My Lord, this is a second bail application. The allegations basically pertains, the allegations are regarding receipt of stolen petroleum products. My Lord, all the sections are that 60 days mandatory below 7 years, save and except one section 317 subsection 4. My Lord, in fact, my Lord, the allegation is that one Imanul Ali had stolen this and sold it to the present petitioner. Now, my Lord, on 26/9/2025, the prime accused, that is Imanul Haq, had already been granted bail by this honorable court, my Lord. I can give the bail number, my Lord. This is one. Secondly, my Lord, the stolen goods had already been recovered, my Lord. No recovery is required to be made, my Lord.
So you call for the CD. Have it on Wednesday at the principal seat.
My Lord, I am deeply obliged.
Same order. Item 3.
But my Lord, there is no public prosecutor, then we will have to inform them.
Yes, you will have to inform.
There
You
is
are
no
there.
public prosecutor. Well, I'll inform.
May I please, Lord? My Lord, in the order, my Lord, Lordship will find at page 7, paragraph 2. My Lord, the PS case number has been wrongly, my Lord, typed out. Because of that, my Lord, bail loan was not accepted by the trial court. Page 8, para 2, my Lord, in my IA.
Bilasipara PS 161 of 22.
My Lord, it should be Bilashipura PS case number 230/25 under section 22C NDPS Act. In para 2, my Lord, line number 3, 4 and 5. Page 8 of the IA.
GR case number is correct.
The case number, my Lord, need not be necessary, my Lord, since it is not mentioned in the FIR itself.
Heard learned counsel for the petitioner. This IA has been preferred seeking correction of a typographical error in the order dated 24/9/25 passed by this court in bail application number 2895 of 25, wherein the PS case number has been wrongly mentioned as Bilasipara PS case number 161/22 instead of Bilasipara PS case number 230/2025 under section 22C NDPS Act. Para, having regard to the above, the paragraph 2 of the said order dated 24/9/25 is corrected as follows. This is an application under section 483 BNSS 2023, praying for grant of bail to the accused petitioner Abdul Khalek in connection with Bilasipara PS case number 230/2025 under section 22C NDPS Act. Full stop. The previous paragraph 2 as appearing in the said order stands deleted. This order shall be read along with the order dated 24/9/25 passed in bail application number 2895/2025. I stands disposed of accordingly.
Deep Lord bless you.
Yes. This one is also with this.
Cases pertaining to Aizawl bench.
May I make a mention regarding item number 5 of the hearing list?
Item number 5,
Of hearing list, my lord.
hearing list.
Yes, my lord. I've been requested by Mr. Priyanshu Goswami that he has some.
Just a
personal
moment,
difficulties.
let me lay my hands on the list.
Yes, my lord.
Yes, item 5.
Yes, my lord. Yes, Mr. Priyanshu, respondent number 5, counsel for respondent number 5, is having personal difficulties, my lord.
Yes, petitioner. Okay. On the prayer of learned counsel for respondent number 5 and with the consent of the petitioner, matter is adjourned. List again on?
After 4 weeks, my lord.
List again after 4 weeks. Yes.
Obliged.
For omission, item 1.
May I please your lordship?
Yes.
Lordship, I am appearing on behalf of Mr. H. Gupta, lordship, for the respondent number 7, lordship.
Yes.
Here in this matter, lordship, I am praying some accommodation to file additional affidavit, lordship. On the last order, it was director, lordship, but we could not file it. I am praying some accommodation to file additional affidavit. Also, lordship, one correction was to be made in the registry. That I could not do, lordship. 1 week accommodation may be given.
For
lordship.
respondent number 4.
7, lordship. It is wrongly mentioned as 4, lordship. That correction I was to make, but I could not physically be present there, lordship.
On the prayer of learned counsel for the respondent number 7, 1 week's time is granted to file additional affidavit and also to make necessary corrections in the previous affidavit submitted on behalf of the said respondent. At least after a week.
Much obliged, ma'am.
Item 2.
My lord, as per the last court order, personal appearance has been called for respondent number 2. If I may, I was instructed to defend the case on behalf of respondent number 2. Then I received instruction wherein they stated that payment along with all the interest had already been paid to the state government in the year 2014 for disbursement. If I may, my lord. I did it.
What is the name of respondent number 2? Who is he? Who is he?
Hitesh Jai.
Hitesh Jawar.
Deputy Chief Engineer.
Yes, my lord. I may be given some more time for filing my power as well as for formal so-called reply, my lord.
So who is appearing for Deputy Commissioner?
Miss Mary. Miss Mary.
You are. The amount was paid in the year 2014 and Deputy Commissioner is sitting on it.
My lord, you have already filed our so-called reply.
You have filed.
Yes, my lord.
Let's see, have you stated there? Is marriage on leave or what? She's on leave. Heard learned counsel for the petitioner.
My
Yes.
lord,
Yeah.
I'm seeking for time for filing a general affidavit upon the respondent number
Okay, all right.
1.
Also heard. Yes. Give you her name, okay. So and so who has submitted a communication dated 7/3/25 issued by the Deputy Chief Engineer Construction, Aizawl NF Railway, addressed to the District Collector Kolasib, stating that the full amount of compensation along with solatium and 12% interest has already been paid by the railways by check dated 28/1/14 for rupees 16,04,00847. Full stop. A copy of the forwarding letter dated 29/1/2014 by which the said check was transmitted to the District Collector Kolasib has also been enclosed with the said communication. Para, it is submitted that learned counsel representing the respondent number 1 district collector is on leave. Full stop. Prayer has been made on behalf of the petitioner to file reply to the affidavit submitted on behalf of the respondent number 1. Further, learned counsel who has submitted the aforesaid communications also seeks time to. You're going to file it in the form of affidavit.
Yes, my lord, as well as a power of Wakalatnama, my lord.
File Wakalatnama as well as affidavit incorporating the aforesaid facts. Full stop. Prayer is allowed. List again after 2 weeks.
Yes, my lord.
Item 3.
May it please your lordship, I am appearing on behalf of Mrs. Carolyn in this present case. Since she has taken up this case in her private capacity, therefore, lordship, as she is on maternity leave, if this matter may be listed again after 3 weeks, your lordship.
Who is appearing?
Your lordship, Mrs. Carolyn, on behalf of Mrs. Carolyn Kelungorpu, your lordship. She's on maternity leave and she has taken up this case in her personal capacity. So
Affidavit has also been filed, I think.
Also, yes, already filed. So it can be listed in the
For hearing.
hearing column also, Your Lordship, no problem.
Is it already admitted? No, I think today it has come for admission, isn't it?
Yes, Your Lordship.
Hard learned counsel for the petitioner. Where is the revision petition? It appears that affidavit has already been submitted. Hence, the revision is admitted for hearing list after 4 weeks.
Much obliged, Your Lordship.
Item 4.
My Lord, since the filing of this contempt petition, the respondent have failed to deposit the awarded amount till date. Now, my Lord, it is my prayer that let severe action be taken against the respondent, because they have filed SLP in the Supreme Court, which was dismissed, and they have also filed a review petition against the dismissal of SLP, which was again dismissed. Then this Honorable Court has passed several orders that their personal appearance may also be called for. If Your Lordship may kindly come to the order passed by this court. I'll take Your Lordship to that order passed by this court. On
Dated?
24/3/2025. Oh, sorry.
I think matter is stuck for service of notice on respondent number 7.
There is newly impleted, but for the rest of the respondents, now it is prima facie clear that they are sitting on the court order and they are deliberately disobeying the order of this court, including the order of the Supreme Court. Your Lordship may kindly come to order 29/4/2025, passed by this honorable court. 29/4.
This 28/6.
In the second last paragraph, Your Lordship will see that if there is no positive in
Just one more. I'm on 28/6. Okay.
29/4 of 25.
Twenty-eight,
29/4.
29/4.
25.
29/5. Who is to deposit the money before the Deputy Commissioner, NPCC?
Yes, my lord.
So who is appearing for these officials of NPCC?
My lord, I am appearing, and the NPCC had received one letter from the Ministry of Home Affairs day before yesterday, and which states that the NPCC were requested to file a curative petition. That letter I want to place it before your lordship. And the respondent number 7.
No, we are not interested in
Yes.
that.
The NPCC, the funds come from the respondent number 7.
Respondent number 7, funds may come from that, but their contemplation of a curative petition has nothing to do with this.
Yes, that is
The
the,
court is not obliged to wait for 5 years for the NPCC or government to approach the Supreme Court.
that is the letter which came from the respondent number 7, your lordship.
Yes. So we direct the personal appearance of respondent number 7.
Yes, my lord. No, the 1 to 6, my lord.
No, the funding has to come from respondent number 7. When the fund comes, then the compensation amount will be released. Until and unless the funds come from the respondent number 7, it cannot be released, the NPCC.
When was the reviewed petition dismissed?
It was dismissed on 19 August 2025. Lordship may kindly see the order dated 29/5/2025 passed by this Honorable Court, wherein it directed to file the respondent to file their affidavit reflecting the steps taken by them subsequent to the dismissal of the review petition. But nothing has been submitted till date.
Where is that letter? What letter is there?
The first paragraph deals with this particular case. Only the first paragraph.
This is simply avoiding.
Yes, my lord.
It doesn't say anything regarding, it is just pushing the ball back into the court, NPCC to file curative petition, and much of what has been written here doesn't make any sense.
That is why, Your Lordship, I am
Doesn't make
saying
any
that
sense.
The respondent number 7 is the funding authority who has to pay in this case. So NPCC has taken each and every step on behalf of the government to file cases and all that. Now, if the paying authority has to take final steps, that is the respondent number 7. And in this letter also is coming from respondent number 7 office.
Your Lordship may kindly see that this letter was issued only yesterday, which shows that they are not taking effective and appropriate steps to comply the order of this Honorable Court. Just before this case is listed today, they have issued this letter. It is my humble prayer before Your Lordship today that the personal appearance of the respondent number 1 to 6 may be called, and they may also be directed to submit their affidavit.
No, what will they do?
Because they,
Even if their personal appearance is directed and they appear, what will they do? The money is not with them.
no, they have to self-explain what they have done and what step they have done, because this Honorable Court, in its order 29/5/2025, Your Lordship may kindly come to 29/5/2025 order, my Lord. Here it specifically orders the respondent to file their affidavit subsequent to the dismissal of review petition. My Lord, they have taken this court for a ride now. It has tarnished the image, the dignity of this Honorable Court by dragging this case for so many years, my Lord. They have gone to the Supreme Court. Honorable Supreme Court dismissed the SLP and the review petition, and today they have placed a letter which is also not in compliance of this Honorable Court order on 29/5/2025. This Honorable Court has specifically directed to file their affidavit.
But respondent number 6 was already, that means respondent number 7 is now aware in view of this.
Yes, yes.
Yes.
Very much aware. The respondent number 7 has to file their explanation now as to why the payment has not been made.
It is all the respondent who has to come personally before this court and explain. If they don't want to explain that in their affidavit, that is my humble submission, my Lord.
7 is aware, but 7 is not appearing before this court. That is the difficulty. Even though they are aware of the case, 7 is not appearing.
My humble prayer today, my
The
Lord,
respondent number 7 must be directed to appear before.
is to pass an order directing the personal attendance of all the respondents and to place their case specifically by way of affidavit after appearing before this court personally. Otherwise, it will lower the dignity and the reputation of this court, my Lord. That they have taken this court for a ride for so many years. That is my humble prayer, my Lord, today.
All right, we'll pass orders.
My Lord, oblige.
You are appearing for today? You are appearing for?
Actually, my appearance is for 4 to 6.
4 to 6.
Yes, yes, yes. Those 1 to 3 were the incumbent. We did not appear for them because they were already not in the office when we filed our power. 4 to 6.
Okay, you are Mr. Subedi.
Yes, 4 to 6. 4, 5, and 6.
All right.
Oblige.
Item 5.
May it please Your Lordship? There's a new incumbent to the post of the Chief Engineer Highways, my Lord. He is the necessary party. If I may be given some time to file an impeachment application for the same.
It is submitted on behalf of the petitioner that a new incumbent has been posted as Chief Engineer Highways and prays for time to complete the said new incumbent. Prayer is allowed. List of when?
2 weeks, my Lord.
2 weeks.
Much obliged.
Item 6.
May it please your lordship, I am here for the petitioner, and my lord, the leading counsel, Mr. Manas Elders, he's from outstation and he could not appear today. And my lord, we are seeking for another 2 weeks' time to file the reply in affidavit if permitted, my lord. And my lord, the interim order passed earlier may continue, my lord.
Yes.
And for the private respondent number 7, madam. They were supposed to file their reply affidavit, madam.
What is the matter?
This matter, the petitioner herein is the proprietor of RR Pharmacy and pursuant to a tender notice issued by the medical superintendent ZMC SHRF in the month of January 2024 had participated in a tender for running the pharmacy canteen for a period
So
of...
the tender process is now stopped.
Yes, my lord.
Since when?
Since 2024, my lord.
No, cases of 25, how can it be stated from 24? What is the interim order dated?
My lord, the issue is that, my lord, the tender was floated and I was subsequently selected to run the hospital canteen. But since they are the highest bidder, my lord, they have come before this court, my lord. Now they are enjoying the interim order and they are still running the canteen as on date, my lord.
This is again canteen of the hospital.
It's a hospital canteen,
It's
my
a
lord.
hospital
Zoram
canteen.
Medical College and Hospital.
Actually, it's a government.
So, affidavit has been filed.
My lord.
You have filed your affidavit.
My lord. The state have also filed, my lord.
State has also filed.
My lord. My lord, let them file their reply and then it can be taken up for admission hearing, my lord.
All right. Learned counsel for the petitioner prays for further time to file affidavit in reply. It appears that the petitioner is enjoying the benefits of an interim order and hence the matter is required to be decided at the earliest. Considering the same, list the matter. Give a fixed date then. Okay, after 2 weeks, give a fixed date. Matter on so and so for admission and attempts. The petitioner may file affidavit in reply in the meantime. It is made clear that no further time to file affidavit in reply shall be granted. List on so and so date.
I'm deeply obliged.
Item 7.
Lordship, in the last court date, the order passed this hearing that the respondent number 1 to 5 jointly filed the affidavit reply. So here the order says that in the joint affidavit filed by all the respondents may again be considered as to whether the same is the proper course by the learned counsel appearing for the same. So in this regard, Lordship, I have gone through our High Court rules. It's not specifically mentioned how to file. However, I have one judgment. Lordship, kindly see para 5 from para 5. I am afraid I cannot endorse the views expressed by the aforesaid decision on the strength of Division Bench decision of our High Court reported in such and such, where the learned judge, none else than Chakravarti and P.B. Mukherjee drew into different but concurring judgment held that a proceeding in contempt was by its nature as proceeding in personam, and a contempt proceeding therefore could not be allowed to acquire the character of representative proceeding. In a similar decision, a division bench of Nagpur High Court in the case of such and such held that when an alleged contemptor did not deny on affidavit on allegation made by the applicant, he ran the risk of the applicant's statement being accepted and acted upon. Mr. Justice Jana made much emphasis in Rule 9 and 30 of the Calcutta High Court contempt of court rules such and such, but I find nothing contrary to the views expressed by the above two decisions of the High Court in the same rule. Clearly relates to the petitioner of the contempt application, and Rule 30 simply outlines the procedures of drawing up the affidavit and does not in any way refer or indicate that an affidavit can be affirmed by a person other than the contemptor, if that person is competent to affirm such affidavit. In the circumstances, I am bound to follow the decision of Division Bench of our High Court as well as the Nagpur High Court as referred to above, and I reject the contention of Mr. Chakraborty for the contemptor. I accordingly hold that in a contempt proceeding, each and every contemptor shall have to file affidavit in opposition positively, and no contemptor can delegate the power to any other contemptor or person to affirm the affidavit in opposition or any other application on his or behalf. The order passed me on such and such stance. So here it appears that, Your Lordship, each and every contemptor has to file separately affidavit. Even in our High Court rules, not even mentioned clearly on that part. However, here in Lordship, contempt of court Guwahati High Court rules 1977, here you can say that in the Rule 7, whenever the High Court issues a notice, it may, if
Guwahati
it
High Court
says,
rules.
I just took from here, Your Lordship, I'm sorry. Kindly speak for us, Rule 7. It's not directly mentioned how to file, but it can be so nothing particularly mentioned how to file affidavit. However, from that Rule 7, you can presume that it should be filed separately. In the case I have cited here, also Calcutta High Court, the contempt of court rules also not mentioned, not indicated particularly with regard to affidavit. So this judgment has made and cited that it should be filed separately.
Yes, from this decision, it appears that you are required to file separate affidavits.
Yes.
If this court allow 2 weeks time will be given to file a fresh show cause replies separately.
You want time to file separate affidavits? No. So, okay, let them file their affidavits. Hired learned counsel for the petitioner. On the previous date, a request was made by the court to learned counsel for the petitioner as to whether a joint affidavit on behalf of all the respondents could be filed in a contempt petition. Full stop. In this regard, learned counsel has referred to Rule 9 of the Guwahati High Court of the contempt of courts within bracket ZHC rules 1977, wherein at Rule 10(1), it is provided that in case of a civil contempt, the person charged may file his affidavit by way of reply to the charge. Full stop. But the rule is silent with regard to the filing of joint affidavit. Full stop. A decision of the Honorable Calcutta High Court has been cited. You write within bracket Samarendra Kumar Mukherjee versus K. M. Lal and others in CR number 4604 within bracket W of 1983. Wherein it has been held that a proceeding in contempt was by its very nature a proceeding in personam, and such a proceeding cannot be allowed to acquire the character of a representative proceeding. And therefore, joint affidavits are impermissible in such proceedings. Learned counsel appearing for the respondents submits that the respondents will individually file their affidavits and seeks some time to submit the same. Accordingly, list the matter after 2 weeks, by which time the individual affidavits shall be filed by the said respondents.
Lordship, kindly fix on after 4 weeks. You have
4 weeks, all right, 4 weeks. Okay.
Item 8.
My lord, I've been appointed as legal counsel for this, and I will be needing at least 2 weeks' time to file a reply.
What is this matter?
It's a civil CRP regarding
regarding Lok Adalat Award, Your Lordship.
What happened in Lok Adalat? Award was passed.
Yes.
That is under challenge. Award of Lok Adalat is under challenge.
Yes, Your Lordship.
Third learned counsel for the petitioner. Ms. Changte, legal aid counsel representing respondent number 1 and 2. 2 weeks.
Yes, my lord.
2 weeks time to file affidavit. Accordingly, list again after 2
Your
weeks.
Lordship, I have one prayer that if the interim order, stay order, which was previously passed, may continue.
It was stayed.
Yes. Your Lordship.
Interim order passed earlier to continue till the next date of listing.
Duly obliged.
Item 9.
Obliged.
Transferred to mediation and cannot be settled.
Not settled in mediation.
Meanwhile, my lord, we have filed affidavit regarding newspaper publication towards respondent 2, 3 and 4.
What paper publication is required? If it was referred to mediation, then all the parties must have appeared.
I am for the claimant, my lord. Respondent number only. Notice upon the remaining respondents is not yet complete, my lord.
So without that, how was it referred to mediation?
Because they are challenging the award mainly on the quantum. That is why, my lord.
Third learned counsel for the petitioner. It is submitted that the matter was sent for mediation but could not be settled. It also appears that service on respondent numbers
2, 3 and 4.
2, 3 and 4 are not yet complete. Hence, what will do? You take fresh steps.
Yes, my lord.
Petitioner to take fresh steps. Barrister post to it list again after 4 weeks.
Item 10.
My lord, in this matter, as per the office note, the ID card has not been returned.
ID card not yet on behalf of respondents. ID card in respect of respondents not yet received. List again after 2 weeks.
Item 11.
My lord, it seems that with respect to respondent number 2 and 3, ID card has not been received yet.
ID card in respect of respondents number 2 and 3 not yet received back. Await service. List again after 2 weeks.
However, my lord, there is a letter issued by the instant respondent number 4 addressed to the Deputy Commissioner respondent number 7, wherein it has been stated that the said respondent number 4 had taken steps for approval with the respondent number 1. If I may place this report before your lordship.
Okay, under next date you can give that. There may be a few, further development by that time.
Obliged.
For order. Item 12.
Lordship, I'm appearing on behalf of my senior, Mr. Johnny Altauchang. And my lord, with regards to this matter, only respondent number 2, service upon respondent number 2 was completed, and your lordship had given us direction as per the last court order.
Have you taken steps for service to concerned police station?
Yes, my lord, but we are unable to serve, unable to trace the address of respondent number 3. So, as per my senior instruction, my lord, if your lordship may kindly allow us to draft notice by way of newspaper publication.
Any report from the police?
No, my
Because last order was that. Before calling for We'll call for a report from the concerned police station then, before newspaper publication. Hard learned counsel for the petitioner. Respondent number 3 is not yet served. As per last order, it was directed that notices upon respondent number 3 may be routed through the concerned police station for service of notice, pursuant to which petitioner had taken steps. Call for a report from the concerned police station regarding service of notice upon respondent number 3. List again after 1 week.
Item 30.
Your Lordship, in this jail appeal, paper book is complete. It had been furnished to us, given to the learned PP. So it may be taken up for hearing in the usual course, ma'am.
Hard learned counsel for the petitioner, learned additional PP. Anybody else also appearing? No.
No, ma'am. I'm the maker.
Paper, it appears that paper book is ready and furnished to all concerned. Accordingly, list the matter for hearing on usual course.
Much obliged.
Item 14.
My Lord, regarding respondents number 4, 5 and 6, service has not been completed, any card not been received. However, my Lord, if with your Lordship's permission, if it may be deemed served as per section 27 of General Process Act, because they are these are the owner and driver of the accident vehicle, and our grounds of in the grounds of appeal have not denied our liability. They have only filed an appeal based on the quantum, and that there was a contributory negligence, and that the income of the claimant. So this may not be, this respondent may not be necessary party. In fact, before the learned tribunal, MSCT, these respondents have not even appeared.
1 to 6 are all owners.
No, my Lord. 1, 2, and 3, these are the claimants in the MSCT.
No, here on the respondents, they are claimants. All right. They have also not appeared.
My Lord, they have appeared.
I am for the respondent 1 to 3, and if I may be
1 to
given
3.
Yes, time to file my counter affidavit.
But what about the
otherwise, my Lord, we can wait for return of the service now.
How will there be service? This is Balwinder Singh, son of Arjun Singh, Beltola, Guwahati. The whole Beltola area is as big as Aizawl. Who will find him there? Better address is not available.
No, my Lord. These addresses, we have them from the registered certificate of the vehicle and the driving license.
What is it you were saying about presumption of service?
My Lord, that since we have taken steps and since these respondents number 4 to 6, they are not necessary party because we have not challenged our liability. We have not disputed our liability. We have filed this appeal, make appeal challenging the quantum of the compensation and the income, the monthly income of the deceased, and also the dependency of the instant respondent number 1 and 2.
Okay, let him file his affidavit first, then we'll see
My Lord.
what to do. Our learned counsel for the petitioner, respondents number 1. Learned counsel appearing for respondent number 1, 2 and 3 prays for some time to file counter. Respondent number 3, 4 and 5 are yet to be served.
4, 5 and 6.
4, 5 and 6 are yet to be served. Await list again after 4 weeks.
Item 15.
My Lord, I have instructions to appear on behalf of the respondent number 1 and 2, my Lord, the claimants, my Lord, and I will be filing my parole within next week, my Lord.
Learned counsel for the petitioner. Learned counsel appears in appearing for respondent number 1 and 2 prays for further time to submit counter. Respondent number 3 is yet to be served. Await service. List again after 2 weeks.
Item 16.
You have to file affidavit.
Yes, Your Lordship, I'm appearing on behalf of the state respondents. If another 3 weeks time may be granted, Your Lordship, to file the affidavit.
None appears for the petitioner. Learned counsel appearing for the respondents prays for 2 weeks time to file affidavit. List again after 2 weeks.
Item 17.
Your Lordship, I'm appearing on behalf of the state respondents in this matter as well. Similar prayer for this also, Your Lordship, for this matter.
Okay, same order.
Item 18.
Please, Your Lordship. Please, Your Lordship. Lordship.
Yes.
This is an application. I
number 175/2025, is to impede the present incumbents of Secretary of the Land Revenue and Settlement Department, Government of Mizoram, as respondent number 7, in contempt case 18/2025.
He has come in place of whom?
Valan Moya, Secretary of the Land Revenue and Settlement Department, Government of Mizoram. And Your Lordship,
IA 175/25 heard learned counsel for the petitioner. This application has been submitted seeking implement of the new incumbent to the post of Secretary, Land Revenue and Settlement Department, Government of Mizoram, Sri Vanlal Moya. Full stop. He has been come, whether you have served a copy on him or not. Where have you stated? New incumbent has come doesn't mean he immediately becomes a contemner. You have to furnish the copy of the order, seek its compliance. If he denies only, then he is to be implemented. Merely because he has been transferred there, he becomes a contemner without knowing what is what. There is no statement as such that you have served certified copies of the order before the new contemner. On perusal of the IA, it is seen that it has only been stated that the previous incumbent, respondent number 3, has been transferred and the present incumbent has been posted in his place. Full stop. However, nowhere has it been stated that the copy of the order of this court, which is required to be implemented, has been served upon the new incumbent whose implement has been sought. Hence, there does not appear to be any reason as to why the new incumbent should be implemented in the present contempt case when there is no allegation of any willful or deliberate violation of this court's order on the part of the new incumbent. Accordingly, the prayer for implementation is rejected. I stands disposed of.
The thing is that when the judgment and order pass there, you have furnished to the government, not personally. So if the change of the post of the
Every change in incumbent requires furnishing it, because this is a action in person.
Yes, Your Lordship.
Who knows, it may be order may be lying somewhere, he may not be even knowing it. That is the reason it is required to be served again.
Okay.
You serve and then file your application.
Supplementary cost list, item 19.
May it please your Lordship, I am here for the respondent 6219. And my Lord, we have recently received the IA and we would like to IA for modification, and we would like to file a short clarification in this IA, and if this matter may come up on next Thursday if permitted.
And heard learned counsel for the petitioner, learned counsel appearing for respondent numbers 6 to 17.
6 to 17, my Lord.
Prays for some time to file a affidavit making certain clarifications to the in the okay, this order is in the IMB. Clarifications, clear is allowed. List again after.
If on next week, my lord.
Huh?
Next week.
Next week. In the next week.
If this matter come up as a fixed item, my lord, on Thursday, if permitted, on Thursday.
This the matter again on give the date.
21st.
I'm so sorry. 23rd is holiday, it seems, my lord, and if it's met on 24th, my lord.
Item 20.
May I please, Your Lordship?
NDPS.
Yes, my lord.
Commercial quantity.
My lord, 337.87 grams, my lord.
Already charge sheeted?
Yes, my lord. It was charged sheeted on 23/12/2024.
All right, heard learned counsel for the petitioner. There is an application under so and so. Call for the scan copy of the TCR along with CD. List again on. Give a date. Okay.
My lord, if it may come up.
Yes, BP.
Yes, Your Lordship. If the matter may be fixed on 29 October.
Item 21.
Your Lordship, this is a similar matter, and this is the first time it's listed.
Similar.
Similar, my lord.
All right, similar, same order.
Part 2, item 12.
May it please Your Lordship. Lord, this is jail appeal, and I'm appointed as the amicus curiae.
12.
Oh, yes, Your Lordship. 12 is the criminal appeal. This is NDNPS, conviction under NDNPS Act, madam. I am the amicus.
Yes.
My lord, yes. Your Lordship, the present appellant along with the other co-convicted persons were convicted on 24/4/2019 to undergo 10 years rigorous imprisonment with a fine of 500 rupees, 500 each, and in default of another 10 days of simple imprisonment. And one of the convicted persons, that is the present appellant, has filed the present jail appeal, my lord. And Your Lordship, it is regarding seizure of ganja, 20.150 kgs on 17/3/2017. And if Your Lordship, I may take Your Lordship to the seizure and arrest memo. There is page 1 of the paper book, my lord.
You have admitted.
Yeah, only in the 313 examination, madam. But there, it is not corroborated by the evidence. There is there is one of my good grounds, Your Lordship. Because on the sole basis of the admission in the 312 examination, it cannot be used for conviction, my lord, unless corroborated by the evidence. It was seized from the veranda portion of the neighboring land, the neighboring house owner, my lord, not from my possession. Moreover, there was no constructive possession as well.
Your name is Vanlal
Zampugin, my lord.
Acha.
Zampugin. Your Lordship, I have 4 grounds, in fact. I would like to rely on 4 grounds.
So the recovery was not made directly from your possession. It was
Yes.
in a house belonging to someone else where
Yes.
some sugarcane
That is true, my lord.
grinding was going on.
Yes. It is nearby the house, the other house. Not from my possession.
Yes. What are your points?
My grounds, my lord, the first ground is that although I had admitted in my 213 examination about my possession, but examination under section 213 CRPC cannot be the sole basis for conviction unless corroborated by the other evidence. And while saying this, my lord, may I take your lordship to page 9, that is the evidence of PW number 1. I'll just make my submission
Yes.
brief, my lord. Page 9 of the paper book, I'll come directly to the cross-examination, my lord.
Page?
Page 9. My lord, at the heading in the middle of the page, cross-examination by Defense Counsel of accused La Sangswala. My lord, I'll read quickly, your lordship.
Yes.
It is a fact that I did not see the SA before the court today. It is a fact that as per the photographs of the SA were not covered with blue color cipollin. It is a fact that the owner of the grinding machine, Fu Herna, is belonging to Vanlal Kriati, who is the owner of the residence nearby. It is a fact that Vanlal Kriati was present at the time of affecting seizure and arrest inside her residence. It is a fact that SA was recovered near the grinding machine. It is a fact that I am presently holding the post of Secretary Rambamol Branch OMA. He is the seizure witness, my lord. It is a fact that there are around 5 houses between my residence and the residence of Vanlal Kriati. It is also a fact that there were some persons in the above mentioned 5 houses at the time of affecting search and seizure. It is not a fact that the excise personnel conducted body search. It is a fact that the 2 excise personnel came to my residence so as to invite me to witness the search and seizure of the SA. It is not a fact that the SA were already opened by the excise personnel when we reached the PO. It is a fact that the grinding machine mentioned above is located at Vanlal Kriati's veranda. I do not know whether the excise personnel received prior information. It is a fact that the accused persons were arrested at around 10 p.m. It is a fact that the SA were not seized from the physical possession of the accused persons. The next page, my lord.
Yes.
The seizure of 3 bags were kept on sugar cane and the same were covered with blue color sipholine. It is a fact that a single packet of sample was drawn from the SA. It is a fact that the sample drawn was packed in my presence, and I'll skip this part, my lord. The next cross-examination. This is the cross-examination by my defense counsel, my lord. I do not know the accused, namely Zamkhogin, prior to this incident. I do not know both the accused were a friend of each other. It is a fact that as per the statement of the accused Zamkhogin recorded by the excise personnel, the SA were belonging to the co-accused, namely Lal Sangjola. It is a fact that I truly believe the statement of the accused Zamkhogin, which was recorded by the excise personnel. It is a fact that the SA were owned by Lal Sangjola as per the statement recorded by the excise personnel. This is the co-convicted personnel. And para 8. I do not have any personal knowledge regarding the involvement of the accused Zamkhogin in this instant case. Para 9. It is a fact that the accused Zamkhogin never admitted the ownership of the SA in my presence. So I would like to point out these depositions, my lord. And page 11, my lord. This witness is the owner of the house where sugarcane grinding machine is there, where the SAC's article was recovered, my lord. This lady, page 11. I'll read the cross-examination, my lord.
Yes.
Yes, my lord. Page 11, cross-examination says that, my lord, it is a fact that I did not see the accused carrying or concealing the seized article at any place. It is a fact that accused number 2 was not known to me before the said date. It is also a fact that the accused number 1 was also not properly known to me, even though I had earlier seen him in one occasion. It is a fact that I do not know anything about much about the antecedent of the accused persons. It is also a fact that I am not aware of the accused involving in any other criminal cases. It is a fact that nothing was recovered from the physical possession of the accused. It is a fact that nothing was recovered from the bags carried by the accused. It is not a fact that the SA belongs to me. It is a fact that I am not sure whether the accused claimed the ownership of the SA or not. So, my lord, she is the owner of the house where the seized article was seized. And lastly, my lord, page 12 is also relevant.
Yes.
Page 12, this witness is the seizing officer, my lord, from the excise department. Cross-examination, I'll come directly to the cross-examination, my lord. These are not rebutted. I admitted that we had not seen the accused persons concealing the seized article. It is a fact that nothing was recovered from physical possession of the accused persons. It is also a fact that the name of the accused does not appear in the information so received. It is not a fact that nothing was recovered from the accused persons. It is not a fact that the accused persons claimed the ownership of the SA. However, the admitted fact is that, my lord, no one, any of the witnesses, prosecution witnesses, did not see the accused persons, including the present appellant, hiding the seized article in the sugarcane grinding machine area. And it was not seized from the present appellant as well. So what my first point is that, my lord, I will be relying upon 2010 volume 12 SCC 310 para 14, my lord. 2010 volume 12 SCC 310 para 14. Para 14 is at page 217, my lord. I may kindly read this para only, my lord. The statement of the accused can be used to test the veracity of the exculpatory nature of the admission, if any, made by the accused. It can be taken into consideration in any inquiry or trial, but still it is not strictly evidence in the case. The provisions of section 3134 explicitly provides that the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence against the accused in any other inquiry or trial for any other offense for which such answers may tend to show he has committed. In other words, the use is permissible as per the provisions of the court, but it has its own limitations. The courts may rely on a portion of the statement of the accused and find him guilty in consideration of the other evidence against him led by the prosecution. However, such statements made under this section should not be considered in isolation, but in conjunction with evidence adduced by the prosecution. So this is my first ground. I'll be relying upon this matter.
Yes.
My second ground is, my lord, this article was not produced before the learned trial court. It was not produced at all, my lord. So it vitiates the trial. This I am saying on the basis of the Honorable Apex Court's decision, which later on I will produce.
Articles may not have been produced, but
Yes.
was section 52A of the NDPS Act complied with?
Yes, my lord.
Photograph, certification, inventory, if all that was done, what was the
Yes.
necessity of producing the articles before the court?
Yes.
What was yes?
Yes, 52A was complied with, my lord.
Huh?
It was complied with.
Then articles need not be produced.
In that case, then I'll come to the other ground. Still, I have the other good grounds, my lord.
Yes.
Then, regarding the weight of the cis article, my lord, it was mentioned as 20.150 kgs, dried leaves with flowering tops. I may take your lordship to the Caesar memo, that is the page 1 of the paper book. The Caesar memo says that I so and so do hereby seize 20.150 kgs of dried leaves with flowering tops suspected to be ganza on this so and so day. I will not read the remaining lines, my lord. So, while saying this, may I take your lordship to the NDPS Act, my lord. The definition of ganza, it is NDPS Act.
So dried leaves are to be excluded.
Yes, that is what I am trying to say, madam. Because commercial quantity is 20 kg.
Yes, section.
Section 2, subsection 3. Subsection 3B, clause B, my lord. It says ganza, that is the flowering of fruiting tops of the cannabis plant, excluding the seeds and leaves when accompanied by the tops, by whatever name they may be known or designated.
What is the meaning of this? Excluding the seeds and leaves when not accompanied by the tops.
Tops.
But here the tops are there.
No, that is what I am trying to say, my lord. I may take your lordship to page 46. This is
Yes.
page 46 is the forensic science laboratory
46.
46 of the paper book.
Yes.
So, my lord, it says, I'm referring to description of the exhibits at the heading. 1, 2, 3, it is given here. 3 exhibits S under so and so of a polythene packet containing dry plant materials with fruiting tops, leaves and seeds. Weighing about so and so, 6.62 gram, marked here as so and so.
So leaves are accompanied by fruiting tops.
Yes, but these are separately, differently mentioned, my lord. Then, in order to clarify my point, I'll be relying upon this judgment of the Bombay High Court and the Andhra Pradesh High Court, my lord. The first one is 2024 SCC Online, Bombay, 2198, Para 9.
If you go to paragraph 7, it is clear that in this case there was absence of flowering or fruiting tops. Nowhere was it mentioned, neither in the Panchnama, in the inventory, anywhere, no mention of flowering or fruiting tops. In that case, merely the leaves and seeds and all, they cannot be ganza. But in this case, it's accompanied by the fruiting tops.
But the evidences, prosecution witnesses evidence, nothing was produced, my lord, and no one had identified the cease article during the trial.
Where is the inventory? Has it been exhibited or not?
Our inventory is at page 51.
Yes. Yeah, also flowering tops is clearly mentioned.
Page 52.
Once it is accompanied by the flowering tops or fruiting tops, there is no necessity of segregating leaves and anything.
My lord, be that as it may, my next point will be relevant, your lordship. The sample to be drawn in respect of the ganza is 24 grams in each case. This is in violation of the in violation of the standing order, my lord.
Yes. How much was taken?
It was taken 6 something grams only, my lord. It is clear from the FSL report. At page 46, my lord. Standing order.
Which rule?
Rule, my lord,
24 grams.
page 2, second page, my lord. Section 2, general procedure for sample storage, etc. Has your lordship got it, my lord? I'll read from 2.1, my lord. The relevant will be 2.3. All drugs shall be properly classified, carefully weighed, and sampled on the spot of seizure. All the packages, containers shall be serially numbered and kept in lots for sampling. Samples from the narcotic drugs and psychotropic substances seized shall be drawn on the spot of recovery in duplicate in the presence of such witnesses, panchas, and the person from whose possession the drug is recovered, and a mention to this effect should invariably be made in the panchnama drawn on the spot. 2.3. The quantity to be drawn in each sample for chemical test shall not be less than 5 grams in respect of all narcotic drugs and psychotropic substances, save in the cases of opium, ganza, and charas, hashish, where a quantity of 24 grams in each case is required for chemical test. The same quantities shall be taken for duplicate sample also. The seized drugs in the packages containers shall be well mixed to make it homogeneous and representative before the sample in duplicate is drawn. So if we look at page 46, it is seen that only from three packages, my lord, these articles were kept in different three packages. And from each package, the first sample being drawn is 6.62 gram, another one is 6.87 gram, and the other one is 7.24 gram only. This is seen from page 46 of the paper book. And my lord, while saying this, I may rely upon the Honorable Apex Court's judgment.
Yes.
This is 2023 volume 19 SCC 364. Para 9.
Page?
Page 364, my lord. I'll start reading from page 371, my lord. This is the quoted line, the quoted sentences starting from 89, my lord. Guidelines issued should not only be substantially complied with, but also in a case involving penal proceedings vis-a-vis a departmental proceeding, rigors of such guidelines may be insisted upon. Another important factor which must be borne in mind is as to whether such directions have been issued in terms of the provisions of the statute or not. When directions are issued by an authority having the legal sanction granted, therefore, it becomes obligatory on the part of the subordinate authorities to comply therewith. And this para 90. Recently, this court in so and so, following the earlier decision of this court in Union of India, Azadi Bachao Adolan, held that statutory instructions are mandatory in nature. I think it is sufficient for me to point out this matter, to support my ground. In fact, standing order to be mandatory complied with, as per the Honorable Apex Court judgment.
Yes.
And so, my lord, these are my grounds, and with this, it's my humble prayer that the present appellant may kindly be acquitted, because the conviction is wrong and illegal. And lastly but not the least, my lord, what I would like to point out is that he had undergone, now he has already undergone the half of the sentence since 2019. And it appears that there is no past criminal record. And he was convicted under Section 20B2 C of NDMPS Act, my lord.
Yes. Prosecution.
May it please your lordship. Your lordship, first I would like to rebut from the first submission made by the appellant counsel, your lordship, regarding the conscious possession, and he stated that he did not admit that he has knowledge of that contraband substance. But your lordship, and also he stated that even though he admitted in his 313 examination, that is not corroborated with the evidence. But your lordship, what I would like to mention here is that the statement which the appellant has admitted was truly corroborated with the statement of by the statement of the prosecution evidence. Your lordship, the learned counsel had read out only the cross-examination part and left out the examination part. So, your lordship, I would like to take you to the examination part of PW number 1.
No, first let's see his admission. What has he admitted in his 313?
Yes, he purely admitted that, and also mentioning that he had another cases. That means he is a habitual offender, your lordship. Examination is in page number 5. If I may read out, your lordship. Page number 5. You were arrested in connection with seizure of so-and-so Ganza. How would you explain yourself? And his answer is, the Ganza belongs to the father-in-law of co-accused Lalsang Zwala. We carried it from northeast Lang Nuam in a pickup truck up to Thingphal village. From Thingphal by village, we hired a taxi up to Rangvamual Aizol. Before we sold the Ganza, the excise people seized the Ganza and arrested us. The Ganza does not belong to me, but we carried transport with the Sangwa. So, your lordship, the place of seizure is Rangvamual, which he mentioned it clearly.
The first one is Lalsang.
Lalsang Zwala is the co-accused. And your lordship,
no, what is you were arrested? The ganja belongs to the father-in-law of co-accused Lalsang Zwala. We carried it from northeast. Fish pickup truck up to Traili village. Hire a taxi to Mysore. He says he is not the owner, but he carried it for the purpose of sale.
Yes, your lordship. And in the next question, your lordship, do you have any other things to say before the court? And his answer is yes.
I wanted to say that I had a similar case before, so co-accused claim ownership. Actually, in
I have
here-
seen this. I have seen this for the third time in Mizoram. Accused persons admitting in 313. This is the third case. In Guwahati, I have not found a single case.
And Your Lordship, here he explained that
They read different books, I think.
why the co-accused has claimed the ownership is that the co-accused feel pity for him that he is having another case that's pending. So actually, seeing his answer, it seems that he is also the owner, that only the co-accused claim ownership because he had a previous case. So Your Lordship, it is very clear and that the accused had possessed this contraband substance and he has conscious possession. And Your Lordship, if I take you to the evidence that is in page number 9. From the 10th line.
Yes, I have read the chief, although he
Yes.
has taken us through the cross. I have read the chief. But what actually appears is that, strictly speaking, minus the 313, he was not carrying the ganja at the time they were recovered.
Exactly,
they were
Your
found there.
Lordship.
That is
But
all.
however, Your Lordship, in conscious possession, it doesn't need to be physical possession. Where there is absence of possession, physical possession, it doesn't mean that he had conscious possession.
No, suppose these two persons were found there. There was the owner, those three nylon bags were lying with the property of the owner, with the sugar cane. So even the owner could be the
No, Your Lordship, in
owner
that
of
regard.
the house. He could be the owner of the samples. If there was no admission or anything like that here, they are saying that he admitted.
Yes.
He admitted when asked that this is mine. That is what they are saying. So this
Yes, Your Lordship, from the examination of the seizing officer, it is very clear that they were sitting next to the place of seizure, in the same veranda only. They were there, near the SA. So when the excise personnel found the SA, they claimed that seizure belongs to them, that seized article belongs to them. So that means they are in that same place. So that
No, suppose they say, I don't know, it belongs to the owner.
But they didn't do that. They
But
claim
their
that
admission, what is the value of their admission
they
before the
admit.
police?
They admit, and when when the seizing officer was examined, and when he was examined at that time, this examination was never rebutted in his cross-examination, not even once, regarding that
PW?
PW number 3, that is the seizing officer, in page number 12. This statement is never rebutted in his cross-examination. If I may read out, Your Lordship.
Who claim themselves as the rightful possessors, okay, of the ganja. Okay, where's in the cross? It was challenged, it was put to him that nothing was recovered from the accused persons.
Yeah, that is
He denied.
that is physical. That is regarding the physical possession. It is very
No,
clear
that is previously. Before, later on they said it is not a fact, nothing was recovered from the accused persons. From the accused persons means both physical and constructive possession.
But in my humble understanding, Your Lordship, it is question related to physical possession.
And he also says it is not a fact that the accused persons claimed ownership of the asset. Next line.
I think this is
Hmm.
this is typing mistake, I guess.
It's like yesterday, same thing.
So, Your Lordship, my submission is that the prosecution has proved the conscious possession, and once the conscious possession is proved, the statutory presumption under section 35 and 55 arise, and which the accused fails to prove himself not guilty. Even during his examination, it is seen that he admitted the fact instead of proving that the accusation made against him is wrong. So he admitted that it is true. And regarding the conscious possession, I would like to submit one citation. 2025 SCC Online SC 122. Your Lordship, I would like to rely on
This place is a, where is this place? District?
Aizawl district.
Aizawl.
Yes. And Your Lordship, I would like to rely on paragraph number 21, 22 and 23. Should I read out?
Which is the judgment?
2025 SCC Online SC 122. Para 21, 22 and 23.
This is dealing with what?
Sorry, Your Lordship.
This is dealing with what?
Conscious possession.
Conscious possession. Okay.
Should I read out, Your Lordship?
Oh, yeah, give. You have a copy?
I have a copy.
You have a copy. Okay. This Rakesh Rajbanshi.
Yes, Your Lordship.
I think you gave this one yesterday
Yes.
also.
That's why I'm asking you, should I read
Yes,
that?
all right.
Okay. And Your Lordship, the second point which the council had pointed out is regarding the leaves and top.
Yes.
Your Lordship, as Your Lordship had already mentioned that in the present case, the scissor was a flowering top along with the leaves, naturally attached with the plant. So there is no mandatory that it has to be separated. So the whole scissor squarely falls under the definition of kanza, Your Lordship. And in this regard, there is no need to separate the leaves and the flowering top because it is attached and accompanied. They are accompanied with each other. So it is a legal precedent that when leaves and flowering top are seized together, the entire mixture is to be treated as kanza for the purpose of weight and punishment in NPS Act. And the next point which he raised is that non-compliance with certain procedure. Your Lordship, I have one citation which I have already cited, even this one yesterday. 2025 SCC Online SC 110. Here I will.
This is regarding standing order.
Standing order, yes, Your Lordship. Para number 50. the conclusion part.
Para 50.
Yes, Your Lordship.
This is what Bharat Ambale.
Yes, Bharat Ambale. So, Your Lordship, in this,
Not mandatory.
not mandatory. Substantial compliance is enough. So, Your Lordship, I would like to conclude my submission that the prosecution has proved beyond reasonable doubt that the appellant has conscious possession, and he knows that he admitted that he is the one who transported for to sell. So, my prayer is to uphold the conviction passed by the learned special court, Your Lordship.
Yes. CAB.